But hey, I have it down as we're 12:01. So in the interest of we're on time, I'd like to go ahead and bring this meeting to order. And one of the first things of order is our Pledge of Allegiance. So if I can get Tally to kind of lead us in that.
All right, everybody, please put your hand over your heart and repeat after me. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation under God, indivisible, with liberty and justice for all.
Well, welcome everyone. I trust everyone is enjoying this Thursday. This meeting's it will not last more than 1 hour, rest assured. Now, if you have any questions and comments, we actually have I'm not sure if our affiliate spotlight is here yet. Haven't had a chance to look at it, but we also have a wonderful guest speaker who will be speaking for about 15-20 minutes. And if you have any questions, feel free to utilize the chat box to keep things less disruptive. Be sure if you're not speaking to go ahead and mute yourself. And everyone should know that if they want to submit a listing, they need to get it in by noon, the previous or the prior day. So with that, Wendy, yes, I want to first ask if there's any new attendees. I'd love to see if you are, please, how do I want to put it? Acknowledge yourself, or let us all take meet you and give you a warm SRCAR welcome.
Hi, I'm Judy Ann Richard. It's my first time here. Welcome, everybody.
Okay, well, what brought you here today? Yeah.
I have a new listing in Temecula.
Oh, are you one of our properties of review?
Yes.
All right, well, cool. Well, welcome.
Thanks for having me.
Thanks for, participating, stepping up, and showing up. Yeah. All right. Anyone else? Hearing none. Wendy, is our affiliate spotlight here from Farmers? Yes, I think he is. So Dan Holloman, you have the floor. Or maybe not. Oh,
no,
that's
he's muted. There you go.
Can you all hear me?
I can hear you.
Okay. A little tricky, but I figured it out. Hey, good morning, everyone, or good afternoon. Thanks for having me, I guess is the first part. I don't know if many of you have seen my face on here. I'm usually on. I've been on for the past, since COVID. It seems like, and rather new to the business. I'm out in Temecula, and we cover obviously everything in the valley. Hey, Charles, my buddy. It seems like all the insurance guys are farmers guys or farmers people. I don't know if that's a good thing or a bad thing, but you know that we're here for you. So, and we want to participate. I just wanted to give you a couple of things about me and again, introduce myself. I've been on most of these calls now since COVID started in March. I'm a newer farmers agency owner. I've been going at this since 2019 and went to a couple of the meetings before when we were actually in person before before COVID started, and anyway, it's kind of changed our whole world, I guess, all of us. It seems like it's affected everybody except for the real estate business, and real estate's been off the hook ever since COVID started. I don't know why, but my brother, or I'm sorry, my nephew in San Diego, who's a real estate guy, he's been killing it since COVID started. I know we can, Charles and I, and even I know Craig Davis is on the calls every once in a while as well. I know we can be a big help to you guys, and here's a couple of ways that we can help you. First of all, if you've been a real estate person for a while, you know that you used to be able to get something called a clue report. You guys remember what that is? If you've been a real estate agent for more than, say, 3 or 4 years, a clue report? Yeah, Mike knows. It's basically a report that tells you if a property has had any claims, or if the person that's buying the property has had any claims in the recent past, I think, 4 or 5 years. What that will do is it will tell you whether or not they're going to have a hard time getting insurance, or if they're going to have a higher rate than the customer who doesn't have any claims against them. You used to be able to pull that report as real estate agents. You can no longer pull that report. You haven't been able to pull it for the last few years, but we can still get it for you. Actually, it's a pretty easy report for us to get, and we can let you know if your customer is going to have a hard time getting homeowners insurance, or if the property that you are trying to sell has had previous claims on it, and it might be a little bit more difficult for the person buying that house to get insurance. We can absolutely, if you give me a call, we can let you know that. I guess the other cool thing about farmers insurance that might be different from other insurance agencies is that with the increased fire line scores and especially in California, as farmers agents, we can probably get you coverage 99% of the time, regardless of where the fire line score is or where the property is located. I know that farmers won't write you. We have lots of options at farmers to make sure that your property gets written and you guys get coverage. Speaking for myself, I know that hey, listen, I'm trying to drive my business and grow, and would be more than happy to help anybody with getting homeowners insurance and getting it on the spot. If you have a property that's closing, and for whatever reason your customer forgot to get insurance, give me a call. I will get it written for you that day. Anytime at all, even on a Saturday, give me a call. My office goes right to my cell phone, and if I'm not in my office, it'll go to my cell phone, and I'll be happy to write to help you out. So just give us a call. That's really, other than just saying, hey, I've been out here been in Murrieta since 2005. My kids have grown up out here. I've grown up out here, grown old out here, and happy to be a business partner and help you guys out any way we can. So with that, I'm going to toss it back to Mike and say thanks for the time. And I guess in November, we'll actually have a live meeting, and I get to feed you guys and bring some stuff. So I'm looking forward to that. So until then, if you need anything from insurance-wise, give me a call.
Dan, thank you very much. And that's one things I did kind of pick up in your conversation is being responsive. And that's one thing to really distinguish yourself from all the other agents out there, is being responsive when called upon. So I picked up on that, and I thank you. Yeah. Next up, now also, Dan, I also want to mention, go ahead, feel free to put your contact information in the chat if anyone wants to ask you any other, any specific questions. So now I get to sort of step into a did you know, I think, when it comes to closed transactions. So last year, what was it? This past week, we had a total of 239 closed transactions. Now, do people think that went higher or lower compared to this last year at the same time? Does anyone give me a thumbs up or a thumbs down? Well, actually, last year at this time, we did a whopping 301 transactions. So we actually did, a lot more last year than we did this year. So yes, Kurt, you were right. I saw your thumbs down. So you get the gold star for participating and being right. So with that, yeah, that's another sign of our lack of inventory starting to affect sales at this point. But I also know a good percentage of you guys are here to hear about our guest speaker today. Now, our guest speaker has been in the Valley here for quite a while, and she really doesn't need any much of an introduction, but I also know she's part of the Eviction Center. And if you want to hear more about that, let's give Debbie Chilson a very warm SRCAR welcome. Debbie, you have the floor.
Thank you. Thank you so much. Good afternoon, everybody. So my name is Debbie Chilson. I work for a company called the Eviction Center. And let me start sharing a screen. What we do is we are an unlawful detainer assistant company. So we do evictions for landlords. That's the bulk of our business. Okay. We have two offices, one in, see if I can get this to come up. It might take a second. My computer's slow. We have two offices, one in Beaumont and one in Hemet. I work primarily out of the Hemet office. We've been in business for over 25 years. We like to pride ourselves on our customer service and our response time as well. I want to talk a little bit about the eviction arena right now. Everything has changed. When COVID hit, it really threw a wrench in evictions and how landlords can do evictions. There was a moratorium for a while. Couldn't do any evictions. Everything was closed down. Even our office was closed down last March. And so, you know, we couldn't do anything. But then the governor, around August 29th, signed Assembly Bill 3088, the COVID-19 Tenant Relief Act, and started allowing landlords to do evictions under very limited circumstances. So another slide. I have to disclose that we're not attorneys and we're not a law office. We're an unlawful detainer assistant company. We're registered and bonded by the state of California to do evictions. Okay, so any information I provide for you today is not for legal purposes. If you need legal advice, we cannot give legal advice. If you need legal advice, we urge you to check with a reputable attorney in the area of law that you're seeking the advice. Okay. Anyways, let me see. Going to the Tenant Relief Act, AB 3088. It was an urgency measure effective September 1st that allowed evictions. In the beginning, there was two time periods. There was rent owed from March to August and rent owed from September to January. Originally, AB 3088 was supposed to expire January 31st. It didn't expire. But before that, what the landlord had to do was now serve a 15-day notice to pay rent or quit. And that 15-day notice was 6 pages long. It had 2 pages advising the tenant of their rights as to COVID. It also provided a blank declaration that the tenant could send back to the landlord if he was going to claim a hardship, and he didn't have to show any proof. If you got that declaration, you couldn't file an eviction. You had to wait till January 31st to see if the tenant would pay 25% of the rent due. Okay, that was for rent between September and January. So the first time period, the rent due from March to August, that was considered the protected time period, and you could never evict for those monies. In fact, those rents due were converted to a civil debt. Okay, and in the beginning, they were going to allow landlords to file small claims for those rent monies, but not until March of this year, but that all changed. Okay. Also, what Citra did, it's called the COVID-19 Tenant Relief Act, was it picked up all the provisions of AB 1482. I don't know if you remember that bill that was signed back in January 2020 before COVID, that outlined certain properties were subject to rent caps and just cause evictions, and certain properties were exempt. Most single family homes were exempt. However, Citra picked up all the provisions of 1482, making all properties subject to rent caps and just cause eviction. So what that means is, if you weren't going to serve a 15-day notice to pay rent and you wanted to serve a termination notice, now you have to have cause or reason for the termination. And that reason had to fall within the limited reasons allowed in the act. Okay. But lo and behold, January 31st came and it didn't expire. The governor signed SB 91, which extended Citra to June 30th, 2021. Okay. We got all new 15-day notices that were for rent from September 2020 through June 2021. Okay, and that's the landlord would have to serve a new 15-day notice now after beginning February 1st, after SB 91 was signed. Okay. SB 91 also had provisions in it that included the statewide rental assistance program. So with that was a way that the governor was trying to appease the landlords and give them a chance to recoup some of the lost rents. Either the landlord or the tenant could apply. If the landlord applies to the program and it's approved based on the tenant's cooperation, the landlord could get 80% of his past due rent as long as he's willing to forgive the other 20% and never evict off that 20%. Okay, so that's in play right now. Okay, let's see. The next slide, I wanted to give you an example. One of the other things that the governor did January when he signed SB 91 was he made it mandatory for landlords that if they were going to ask for rent on a 15-day notice for rents due prior to February 1st, they would have had to serve, or not serve, but mail out this informational notice that's on the screen right now. That notice had to be mailed to the tenant that owed past due rent before February 28th to preserve their right to ask for those past due rents. If the landlord didn't do that, then they couldn't ask for any rent from September to February on a 15-day notice. So we've had a lot of clients call in February saying, well, I have a tenant that owes rent going way back. Well, did you send the notice by February 28th? No, and no, most landlords didn't know about it because it's just like, just thrown at them February 1st. And I said, well, you can't ask for those rents, but you can starting March 1st. So that's what we've been doing moving forward. If the landlord did not mail this informational notice to their tenant, then they would have to wait, and they could serve a 15-day notice starting asking for rent March 1st. That was a little wrench that they threw in there. Okay. Wanted to give you some examples of the notices. Let's see. Here is a sample of the 15-day notice. This slide, I'm going to show you 3 different slides because this notice is so complicated and so long. So the first 2 pages, as you can see, 15-day notice to pay rent or quit with blank declaration of COVID-19 related financial distress. And it goes down the line, including September through March, and then the second page is April through June. And it gives all of this legal information and then the information that's required to pay the rent. Okay. The page 3 and 4 are the 2 pages advising the tenant of their legal rights. Okay. And then page 5, the last page, which is the blank declaration provided to the tenant they could return if they're going to claim a hardship. And again, they don't have to show any proof. Okay. That's if the landlord wants to try to evict for non-payment of rent. Now, if they got the declaration back, they'd have to wait till June 30th to see if the tenant paid 25%. They could not file an eviction until that time. Okay. If they don't pay, then they can file an eviction July 1st. They did not get back the declaration. They did not get any payment of any rent, and the tenant did not move. They could file an eviction based on that 15-day notice. But it's very risky at this time because the courts are so lenient on tenants right now. And they're allowing the tenants, if you filed an eviction, to provide this declaration late in court, attached to their answer. And if the court finds good cause that why they didn't submit the declaration timely to the landlord, then the landlord's case gets dismissed and you wouldn't be able to follow through with your eviction. So it's very risky at this time even to file an eviction for non-payment of rent. Okay. But we have evictions. We've been doing evictions off of other reasons. I have several cases right now going off of covenants notices. That's where you have a written contract and the tenant is breaching one of the covenants, unauthorized occupants, unauthorized pets, serious trash about the property, rule violations. You serve this 3-day notice to perform conditions, covenants, or quit. And if they don't clear up all of the violations within 3 days, then you have a right to serve this second notice, 3-day final quit for breaches because they didn't comply with the first notice. And if they don't move after that, then you can file an eviction using both notices. And we've been pretty successful with those cases. You just have to make sure you have witnesses available to testify as to the breaches of the contract, okay? And then we're still doing the 3-day quit notice if you have, this is a specific notice as to a crime-free lease addendum. So if you have a tenant that has a crime-free lease addendum signed and they commit a crime on the property, or one of their guests commit a crime on the property, you still can serve a 3-day quit notice and file an eviction off of that. That's still available to you. Now, commercial tenancies are exempt from the COVID-19 Tenant Protection Act. We can still do 3-day notices to pay rent on commercial properties. It's not affected by COVID at all. Okay. Also, transient tenancies like mobile or motel rooms and things like that, those are exempt as well. We also are doing a lot of evictions off of notices to terminate. And I wanted to give you an example of a couple of termination notices. However, because, like I said earlier, the AB 3088 and SB 91 picked up all the provisions of AB 1482, just cause evictions. You cannot serve a termination notice unless you have a cause or a reason to terminate the tenancy. And it has to be one of the reasons allowed in the law. Number one, you can terminate the tenancy if the owner needs to move into the property or he has an immediate family member that has to move into the property. As you can see on this notice, it has all the reasons here that you check the boxes. Number two, owner intends to withdraw the premises from the rental market. That's risky though, because if you use that reason, you can't rent the property out for another 10 years. Number three, owner intends to demolish or substantially rehab the property. That can be used only if the property has habitability issues that require that the landlord is being required to comply with city, state, or county statutes, codes, or ordinances. What that means is the property is in serious disrepair. It doesn't mean, and I've had clients say, well, I want the tenants to move out because I want to sell it, but they're trashing it and I want to remodel it and make it look pretty and put in marble countertops and repaint and new flooring. That's not the same thing. It has to be serious damages to the property that are habitability issues where the property has to be totally demolished or substantially rehabbed. So that's another reason. Another reason is owner has entered into a contract to sell the premises to a natural person, a buyer who plans on moving in. Okay, so those are the main 4 reasons that an owner can terminate a tenancy. Any other reason you can't terminate. So I have real estate agents call me all the time saying, I need to terminate, my client has a rental and he wants the tenants to move out because he wants to put it up for sale. Can't do that. You have to have a buyer in place with a signed purchase agreement before you serve the termination notice. Okay, and that's difficult because buyers want to move or they want to go inside and view the property before they sign a purchase agreement or submit an offer. So it is difficult, but I do have clients that have gotten it done and we've served these notices. In fact, I served 2 of them or prepared 2 of them this morning to be served today. So also the same old rules apply. You cannot terminate a tenancy unless you're in a month-to-month contract. If you're in a lease with a beginning date and an end date, you can't terminate a tenancy at all. You have to wait for that contract to expire or that lease to expire and convert to a month-to-month. Number 2, if they've been in the property for less than 1 year, it's a 30-day termination notice. More than 1 year is 60-day termination notice. Some Section 8 properties require a 90-day termination notice. But again, you have to be in a month-to-month contract status. Okay. Here's another termination notice that we use. This is from the California Apartment Association. This is the one specifically, notice of termination of tenancy due to owner move-in. And it says right here, it's either the owner or their spouse, domestic partner, children, grandchildren, parents, grandparents are going to occupy the unit. That's a legitimate reason to terminate a tenancy. Okay. Now, another thing to remember, when the landlord is terminating the tenancy for a no fault, just cause reason, it's not the fault of the tenant, like these reasons, you're also required to provide relocation fees to the tenant equal to 1 month's rent. And in the bottom half of the notice, it outlines that. And you can pay those relocation fees 3 ways. One, you can pay them an amount equal to 1 month's rent 15 days after the notice is served. We don't recommend that. Number 2, you waive the last month's rent. You just waive it. You don't expect to get it. You tell them they don't have to pay it. Or number 3, if they haven't been paying rent and they have a past due balance, you're allowed to deduct 1 month's rent off the past due balance in lieu of relocation fees. So it would be either reason number 2 or reason number 3 that you would, comply with the payment of relocation fees. But this is the notice we use for that reason to terminate a tenancy. Okay. So then the next slide is basically a flow chart of how evictions work. I had a realtor call me yesterday. We did a 60-day notice, and he said, well, if they don't move out after 60 days, can we have the sheriff come? And I said, no, the sheriff is not going to come out on a notice. A notice is not an eviction. It's just a notice, but it's what starts an eviction. That's why it's very important to have the proper notice served, so that if they don't move, you can file your eviction and the court won't dismiss your case because you used an improper or invalid notice. That's very important because the case is based off the notice that's served. Okay, so basically, you serve a notice. If they don't comply with the notice, they don't move, or they don't pay whatever that notice is asking them to do, then you have grounds to file your unlawful detainer with the court. Then that's filed with the court. Evictions right now are taking 2 to 3 months to go through the court process because of the way the court is processing the paperwork. It used to be our fastest eviction prior to COVID was 19 days. On average, they were 30 to 45 days. Now it's 2 to 3 months because we still can't walk inside the court and file things over the counter and get immediate paperwork back. Everything either has to be electronically filed through the web portal, back filed in San Bernardino, or mailed into the court. There's no consistency whatsoever with the courts. A lot of our cases are filed at Southwest Justice Center. Southwest is pretty good. They take 2 or 3 days to process e-filing. They take 3 weeks to process mail-in filing. Moreno Valley Court takes a month to 6 weeks to process both electronic filings and mail-in filings. It's really sad. I have one case in Moreno Valley that it's been going on for 6 months now. And the client is just, and he sold the property, and the buyer is still waiting to get the tenants out to move in. So it's just, the courts, because the restaurants are open and things are opening up, doesn't necessarily mean the courts are going to automatically open up. They will decide when to open up when the presiding judge in Sacramento of the the main judge up there decides to do an order for the courts to open up again. But right now they're not. You cannot walk inside a court except for emergency matters like ex parte motions or restraining orders. Those are the only cases that you can walk inside the court and file things over the counter. In any event, this is a flow chart that shows the eviction process. The tenants get served. If they don't answer, we do a default judgment for possession only. If they do file an answer or response, we set the case for trial. All trials right now are telephonic, over the phone. So we've been doing those. We used to file 50 cases a month before COVID. I think I've filed about 55 or 60 cases since October. And I haven't lost one single case. I have about half of those still in the process in various stages. But we're getting lockouts, we're getting rips, we're getting the property back for the landlord. Here's a slide that talks about how an eviction is served and what the process server has to do. There's personal service. Personal service means that we hand it to the named party. Substituted service means we hand the paperwork to somebody other than the named tenant, but they have to be over the age of 18. And we cannot do substitute service until we've already made 2 attempts at personal service unsuccessfully. And then there's posting and mailing. That is done only by way of a court order. There's a lot of people that evade service. They know it's coming, so they don't answer the door. Unlike a notice can be just posted, very easy, and anybody can serve a notice. The court paperwork, the eviction papers, in order to post them, we have to get court order signed by the judge authorizing the process server to serve the summons and complaint by posting it on the door, and we mail copies by certified mail. Okay. Now, how they're served determines the timeline of your case. If they're personally served, they get 5 business days to file a response. Substituted service or posting order, they get 15 days to file a response with the court. So we can't file a default until those number of days passes, giving them a chance to respond. Okay. A little bit more about the posting order. That's what we have to do to get a posting order. We have to provide a declaration of due diligence showing all the attempts the process server did and to get them personally served, to get somebody to open the door. Okay. Then some eviction do's and don'ts. Do not turn off the resident's utilities. Can be a felony. Can be considered retaliatory. You can be fined $100 a day by fair housing. Do not file your unlawful detainer action prematurely. I have a question asked. Well, my client needs the property back now. Can we file it now before the 60 days is up and, get in the queue so that, we can get things going? No, your case will get dismissed. You have to give them that 60 days to move. And then when they don't move, they're guilty of an unlawful detainer when you file your case. You cannot accept rent and evict at the same time. If you accept the rent while the eviction is going, the case will get dismissed. Okay. After your eviction, you get a sheriff lockout. At the lockout, if there's the resident is there and they get kicked out by the sheriff, and they have all of their things inside the house, you have to keep their stuff safe for another 15 days and allow them an opportunity to make arrangements with you at your convenience to come back and get their things. Whatever's left after 15 days, if it's less than $700 garage sale value, you can trash it. And 99% of the time, the stuff that's left is just end tables with broken legs and couches with tears and stuff they don't want anyway. You would not be able, the value is less than $700 garage sale value. Also, it's very important to remember, anytime you have a tenant move out, whether it's voluntary move out or an eviction lockout, within 21 days, you must provide an accounting of the security deposit. If you're deducting less than $125 and you're going to be giving them a refund, you don't have to provide receipts. But if you're deducting more than $125, you must attach receipts to substantiate those deductions. Okay. If you don't do that 21-day notice, the tenant can sue the owner in small claims court for 3 times the amount and win, just for the mere fact that that wasn't sent out within 21 days. A lot of times you don't know where the tenant moved. Well, you're not required to know that. You just need to mail that letter to the last known address, and one of 2 things will happen. Either if they put a forwarding order in, it'll be forwarded to them and they'll get it. If they didn't, it'll be returned to you. In any event, you have proof that you did what was required by law, by the civil code, and that will protect you. Okay. This is a guideline, security deposit deduction guideline, just a guideline, just to give you an idea of what you can and cannot deduct. And that's it. Do I have any questions? I know it's one of the most popular questions is what's going to happen June 30th? I get asked that every day. I don't know. We just don't know what this governor is going to do. We're hoping and praying June 30th, all of these restrictive laws expire like they're supposed to when we go back to the old way of doing things come July 1st. That's what we're expecting. We have not seen anything in the news or on any of the websites, or the California Apartment Association monitors these things very closely. We haven't seen any indication that anything's going to be made permanent with these 15-day notices or, just cause evictions or restrictions, but we never know. And we don't know until the last minute. For instance, the moratorium last summer was set to expire August 31st. August 29th, 2 days before the governor signed AB 3088, and we found out about all this. That was supposed to expire January 31st. 2 days before that, January 29th, he signed SB 91 extending it to June 30th. So we're probably not going to know what's going to happen until June 28th, 2 days before. We might see something, and so I can't really give anybody an answer what's going to happen other than we just hope that things go back to the old way of doing things. So,
Question?
yes.
This is sort of related to this, but a person has, my friend, his father died, right? And he's trying to take over the property. But the problem is downstairs, his father had let these people move into their house, no contract, no nothing. But they are under the color of law staying in there because of COVID, you know? And I wondered, yeah, I wonder.
He would have to serve probably a 60-day termination notice and choose which one of those reasons. If he wants to move into the whole house, is it like a duplex or is it?
It's a split level house where it's a house upstairs and then you go downstairs and there's another house kind of thing.
Was it intended to be a single family home in the beginning and then he just let them move in downstairs? And
what his attorney did is apparently the father didn't set it up with the system that's saying that he was using as a rental down there. So they went through that paperwork and stuff. And while it was going on, you know, this COVID and stuff like that, that they were like, you can't evict me, you can't do anything because of the COVID. And I was just wondering, you know, on the other end,
he has to serve a termination notice, but he has to give cause as to why he's terminating their tenancy, and it has to be one of those reasons. So if he has,
because it's non-payment, and
if he wants to move into that part of the house, he can do that. If he wants to have another family member move in downstairs, he can use that reason. He can use the reason that he's removing it from the rental market if he's going to just keep the whole house to himself. That just means
it could be the other. Could it be that he because I think they're in the process of making it into a rental downstairs and you know, making it correct so that if they do ever have anybody else, you know, they'll have a contract and the whole bit.
He can't use the reason that he's removing it from the rental market because then you can't re-rent it for 10 years.
Oh no.
So
see, he didn't never really rent it. It's just a buddy coming in and he giving, you know, I mean,
true. I know, but that's in landlord-tenant law, they're tenants. Whether they pay
they're still a tenant. Yeah, once they've been there for 30 days or more and all that stuff. Yeah.
I mean, there's no written law.
But he will be able.
Once they've been there for so many days, I mean.
Yeah, there is one.
If somebody was there for 2 weeks and they refused to leave, you'd have to serve a 30-day termination notice with cause.
Right. It's just because it's, you know.
In interest of time, I'd like to
Sorry.
sort of go ahead. Oh, I know. Interesting. I do appreciate some great insight there, Debbie. I also know you had initially put your information in the chat, but also know a lot of people signed in after you did, so they can't see that. So I highly recommend put your contact information in there again real quick. And also loved your PowerPoint. And I'm kind of thinking if anyone wants the copy of your PowerPoint, we can probably have them contact you directly.
Either me or I emailed Wendy the link to it, so she can email it out to people as well.
Okay, so if anyone wants it, either contact Wendy.
I put the screen shared our office locations with our address and phone number and email.
Awesome. And I don't know, I don't know if we have any other questions. No one really had their hand up.
With this one and not.
Yeah, what I'll do, we can go ahead and move on to our wants, needs, or price changes. Because it's already quarter till 12.
Sorry, I took an hour-long presentation and tried to condense it.
All right, next up is our education chair. So Barbara.
Good
Barbara.
afternoon. Hi, Barbara Rand here. Hey, just want to let you know that not to fear, that I keep telling you every week that John Giardinelli and myself and a group of individuals are going to be teaching the residential purchase agreement, the new one that's coming out in December. We're going to start in August. CAR is also going to have a bunch of those courses. I recommend you take several of these classes from several different instructors just to really get yourself acclimated to the new RPA, but it's going to start in about August. And then next month we have our SIG class. I don't see, I thought we had Cynthia on here, but she's not on here anymore, about the SIG class, which is next month, June 22nd. We've got the best practices working with buyers. And I do see, no, she left. Pauline, I thought Pauline was on here. She was on here. I was hoping she would talk about our this particular day that we're going to be changing to, and I can't remember. I'm part of the committee, but I can't remember. But Pauline is the chair, so I guess we'll talk about it next week. But it's going to change the date, and we're also going to start, I think, in July. I can't remember exactly the day, unless anyone wants to save my life right now. Exactly.
Barbara.
Yes, Tracy. Oh,
Right.
thank you, my love. Okay.
The first Tuesday, yes.
July
In
6th.
July. Yes, we go back
Okay.
to 9 a.m.
Thank you for saving me, Tracy Garamone. Yeah. And so that's going to be a Tuesday, right?
Yes, that's correct.
Tuesday. And
Yes.
what time is it again, Tracy?
But we're going to start at 9. It's
At
Alicia.
9. Okay. So
I tag teamed Tracy.
like before. So Tuesdays at 9 in person. And I think that we decided we're also going to do a hybrid of Zoom in case anybody still doesn't feel comfortable coming out. That's my idea of it. I was there, but I'm on pills and I'm very, very dizzy, so I don't remember everything. I did write notes down, but I don't have them in front of me because I'm not prepared. So having said that, I'll let you guys go because we're almost out of time.
But your hair looks amazing. I love your hair.
Oh, thank you. I cut it, and it's real pain now. because
Sorry, I had to say something. I'm a girl.
Thank you, Alicia. Okay, all right, bye, guys.
If you haven't lost your gift of gab, Barbara. That's
I
something.
know. I have no economy for words. I know.
All right. With that said, yeah, that's awesome. I don't see anyone here from the MLS task force, but I assume everyone got the new protocols when it comes to open houses and showing guidelines. CR was very active over the weekend. I think Monday I got the email. And yeah, definitely a shift there. So if you do not have the latest PED forms or the open house forms, check them out. That's my 2 cents when it comes to MLS forms. Anyone from property management? I think we just talked about the eviction center. I think that pretty well covers it. YPN, Jenna / Molly or
Hey guys, Jenna, I don't think Jenna's on the call, but we do have an event that is actually next week on the 25th. And I am like Barbara, I don't have it in front of me, so I apologize. But I'm sure Wendy will pull it up because she's amazing like that. No? Okay, sorry.
It's at Shamrock. Here, Molly.
It's at Shamrock. Those are the 2 things I know.
It's at Shamrock on Tuesday. It's just going to be a networking happy hour. There's no cost to attend. It's no host, bar, or drinks. It's more just to get out and see everyone in person. We are going to be doing some raffles to support our charity of the year, which is the Love Song Foundation. So there will be raffle tickets available for sale. But it's more just come out, show us your face that we have been deprived of seeing over the last year. And it starts at 5. I think it's 5 to 7. I believe are the times, but Shamrock right here in Murrieta.
I'm all for that. You're getting face to face, especially with a beer. Yeah. Now, Molly, you want to share a little bit about scholarships? I know today's the last day to get the applications in, huh?
It is. You have 2 hours and 1 minute to submit your applications for scholarships. So hopefully, if that was on your list of things to do, you have already taken care of that. But this is your last and final reminder. You got about, now you're at 2 hours. So get it done. And also, thank you to the affiliate committee and the Hammett Events Committee and all these committees that are coming together to support the Scholarship Foundation this year. It means a lot.
It's awesome. Yeah, I mean, you're investing in our future there. So yes. With that, anyone from the legislation chair or legislative chair? Seeing none. How about WCR? I don't see Curtis. It's hard to miss Curtis if he wasn't. Is anyone from WCR want to say anything in Curtis's behalf? I'm looking at you, Alicia.
No, they have an event coming up and I was struggling to figure out the date. They have, it should be on, it's on the calendar, or check their website. It's Health and Wealth, and they're totally going to be working out together. So that's a good event.
That's enough. Well said. Now, also know we're right at the wall. We're at 1:01 now, and I want to respect everyone's time. But also know Wendy's got do you have any more slides you want to show us? Or can I go ahead and, I don't think I have any town choirs to speak of. So I want to go ahead and wrap this up. So this is last moment. If you have something you need to share and you can't hold it in any longer.
I can't hold it in any longer. I'm so thankful we're going live.
I think we're going live, and I think in July we're moving back to Tuesdays. The rumor has it. You didn't hear it from me, but keep that Tuesday mornings open for you. Okay, with that, I wish I had an inspirational, motivational quote for you, but I don't. But I do know, go seize the day. And we'll see you guys next Thursday.